So make all the dictators giant mecha versions of themselves in video games moving forward, and we're fine. Okay.
Hello, fellow netizens, and welcome to Scandalous Games, the show where we take a closer look at video game-related controversies. I'm Kevin Impellizeri, and I do the research and share a story of a video game-related controversy to my friends.
I'm Phil, and you might as well consider me a video game newbie.
I'm Andy Hunter, a longtime fan of all things Nintendo.
I'm Kate, and if I am not depicted as a giant crime-fighting robot in the video game about my life, I will sue someone.
All right, let's pick up our discussion we started last time as we continue our long deep dive into college sports and its relationship to video games and how we got to the point we are with College Football 25. So last time, we finally started looking into the ways that college athletes used video games and their likeness rights within those games as a battlefield over the larger discussions of the way they are treated by the collegiate system, which up to that point made billions of dollars for the NCAA and for schools and conferences and the various corporations connected to it, but somehow left nothing there for the athletes. And we learned about how former athletes like Ed O'Bannon, Sam Keller, and Ryan Hart then took to their likenesses in video games, suing Electronic Arts, suing the NCAA, and other related organizations over their likeness rights. And we use that as a way of jumping off to talk about other legal debates over likeness rights, including the likes of musicians like No Doubt and Adam Levine, and then eventually Panamanian dictator Manuel Noriega. As the Noriega lawsuit shows, these cases, both of famous musicians and college athletes, sparked an intense debate over the relationship between the rights of people to capitalize on their own images versus game developers' right to free speech. And so the attorneys of No Doubt, Dave Mirra, Noriega, and the like, they argued their cases on the grounds of a legal precedent called the right of publicity. So again, gotta say up front, as I always do when I dive into legal topics, I am far from a legal expert. If we have actual legal experts who listen to the show and want to weigh on this, feel free to do so. scandalousgamespodcast@gmail.com. I'm totally ready to be corrected on this. And so I'm going to give you basically like a Cliff Notes version from a total layperson's perspective on the right of publicity. So the right of publicity is basically the right of a public figure to have a say in whether or not they or another party can capitalize on their name or image for commercial purposes. The concept as part of American legal precedent dates to a case from the 50s called Halen Laboratories Inc. v. Topps Chewing Gum Inc., which was a 1953 ruling on the use of baseball players' likenesses on baseball cards, where the U.S. Court of Appeals for the Second Circuit ruled a person or their estate had an economic right over their own images. In this case, it was representing their images on baseball cards. Defenders of college athletes emphasized that EA was exploiting their images in a similar way to players on baseball cards by presenting their digital likenesses, even if they were unnamed in NCAA-themed games. So again, going back to this right of publicity. This is a public figure. What freedom do they have to have agency over their own likeness? On the opposite side of this, supporters of EA and Activision, as well as their respective legal teams, argued in their defense on the grounds of free speech protection, essentially saying that EA, Activision, and other video game companies should have the freedom to depict notable figures without fear of creative restriction. Like, for example, will a game company have to make sure if they depict a public figure, such as a head of state, that they get permission from said head of state, who would then have creative control over how they're presented in the game? So a lot of the concern for game companies, at least the way of presenting it in the courts, is like, if we start getting into this position where like we can't depict a public figure without their permission, that's going to start restricting our free speech. What if, for example, in the case of Noriega, we're depicting him negatively, and he now has to come in and be able to say, well, I need to give you my permission, but I also get to have a say in how you depict me. And I think that's the way they argued for public figures like presidents, like going back to Call of Duty Black Ops, the fact that, you know, they have these caricatures of Richard Nixon and of John F. Kennedy in there too. It's also really important to note that from a contextual standpoint, that while the O'Bannon, the Keller, and the Hart lawsuits made their way through the courts, video games as an artistic medium were undergoing a fundamental change in their standing in the eyes of the U.S. law. And during the 2000s, several state and local lawmakers attempted to pass bills restricting access to violent video games. We've covered this topic before, citing all sorts of alleged harms if children got their hands on naughty titles like Grand Theft Auto 3 and Manhunt and Postal 2 as a justification for why they needed to be censored or banned. And so you saw a bunch of these bills, as we've talked about in the past, introduced into state legislatures, and a couple of them get passed. Those that get passed were all challenged in the courts by the video game industry on the grounds that it was actually restricting their free speech, to restrict these content or access to them. And this was a series of legal battles through the 2000s, and all that culminated in a Supreme Court case where on June the 27th, 2011, in the case of Brown v. Entertainment Merchants Association, the U.S. Supreme Court, by a 7-2 margin, ruled that video games qualified for free speech protection. The ruling struck down a 2005 California law banning the sale or rental of violent video games, which the bill defined as a, quote, video game in which the range of options available to a player includes killing, maiming, dismembering, or sexually assaulting an image of a human being, end quote, to anyone under the age of 18. It also required any video game with violent or sexually explicit content to bear a 2x2-inch label on the front of the packaging with 18 printed on it to warn players and retailers of its naughty content. And longtime listeners may recall that the bill was introduced by then California State Assemblyman and later convicted arms trafficker, our old buddy Leland Yee. Hey, Leland, how you doing? I know he's out of prison now. I don't know what he's doing since he got out of the joint. But and if you want to learn more all about that, check out our Brown v. EMA episode, including the exploits of our buddy Leland.
Kevin, is it okay if I weigh in on a point you made like a minute ago?
Go for it.
So when they were talking about free speech and public figures, like, shouldn't there be some sort of distinction being made in the free speech zone about whether the character is being depicted in a cutscene versus their depiction being materially necessary for the gameplay? Like Michael Jordan in NBA Live, it's like, it's not the same game if you can't be him taking the last shot, right? Like doing the fadeaway in the mid range. But if it's Manuel Noriega in a cutscene that's prefacing you going in and, doing whatever shoot 'em up you want to, like, they're different things. Like, I think the cutscene fits more in the free speech zone, but I think NBA Live is like, no, that's actually something somebody needs to be compensated for. In my mind, I am not a lawyer, but like, that's what occurs to me in that zone.
Interesting. I would think the distinction would more be, if I were to make something up as a non-lawyer, apart from all the times on the show that I've claimed to be a lawyer, I would say the distinction would be if you are depicting something that is agreed upon as historical fact, then sure, a public figure is a public figure, and history belongs to all of us. But if you're making up, a news story that involves Manuel Noriega or Kurt Cobain or whatever, then you do need those people's permission, because at that point you're not really using them as a public historical figure anymore. You're using their likeness to create something new. Like that's
Speaking also as not a lawyer, that would leave a lot of wiggle room. Like, it's like, okay, I was there, but I never said that thing that they had me saying in that cutscene, or you're not giving context appropriately or something. And where does that leave like alternate history games or things like that, where it's like Kevin, like what you were saying, the one where it's simulation or something like that.
Like in the Call of Duty game, it's a
Thank you, yeah.
it's
Yeah.
it's a simulation of Manuel
Yeah.
Noriega, not the real
Yeah.
Manuel Noriega.
I think something that you were saying though, like, it's hard not to depict Noriega as a dictator, even if you're having him say or do something in the game that there's not like footage of him having already done. That is his reputation as a public figure. If somebody made a Scandalous Games video game and decided to make my likeness in it and made me just like a really bad person who did very bad things just for whatever reason, and that's not how I'm depicted publicly, I could see that feeling much more like a personal attack and much more like a smear campaign over use of free speech. And then the other point, Phil, I wanted to go back to what you were saying too. I think where I might be in a cutscene that is material to the game's story, but you could just as easily skip that cutscene or have even cut it out per se. No one's buying the game specifically because of that cutscene. People are buying these NBA games because they want to play as Michael Jordan. If they bought that game and they couldn't play as Michael Jordan, they wouldn't want to buy that game.
Exactly. Yeah. Thank you.
Yeah, I think that's an excellent point right there. Yeah, no one's lining up for the newest Call of Duty game. Oh, great! I can see Manuel Noriega in it.
Now, if you could play as Noriega, I don't know. Oh, there's a lot of weirdos out there. Maybe they want
Play
to.
as Noriega.
So I guess if you can make the character do something or you take on the avatar, it's like at a different level than if the character shows up in the game and has a historically accurate depiction of themselves.
There's also, you remind me of two things. One we'll cover a little bit later is there's an idea in copyright law in particular called transformative works. You could make the argument if we're taking an original work, a copyrighted work, and in this case, we'll talk about the likeness of a figure, and we make enough significant alterations to the point that it becomes its own thing, like, and that you're not trying to represent that as the actual thing. So, like, our Cyber Noriega is a good example of that. We're seeing them as like basically a villain character that we're putting in this game that just happens to be named after a recognizable figure. You could probably, again, not a lawyer, you may be able to make the argument that this is both because they're a public figure and this is what they're known for, that he is known for being a Panamanian dictator and he's doing Panamanian dictator things, that you could then say, well, we are just representing that. And also you could say, well, no one's going to confuse this for the real Noriega. I don't think anybody's saying, wow, Noriega lent his face and his voice to this game. And the other part that got me thinking about this too, that you brought up, Kate, is like, it reminds me of the whole debate over deep fakes, where we have a kind of AI generated digital recreation, particularly of it comes to publicly recognizable figures who are then made to say or do basically anything they want to generate them to do, and oftentimes doing things that are antithetical to their image and trying to pass them off as the real thing. And I think that might be one of the distinctions too. Like, no one's making the confusion that like this digital Noriega is the actual Noriega, whereas in the situation of like a deep fake, where it's like, Kamala Harris saying, what, I actually endorse Donald Trump for president kind of thing, where that is trying to pass this off as a real person and misuse them in that way. And that's where my brain kind of got to, was the idea of like the legal debate over deep fakes now.
Kevin, that's interesting because I actually got to see LeVar Burton speak last week. One of the thrills of my life. Like, I love LeVar Burton for reading Rainbow first and foremost. And he made a comment about like generative AI and its ability to produce things in your voice. And he just said what disturbed him is like, who has control over my voice now? Is it me? Or is it someone or something else? And like, once you dispossess me of my voice, like what does that leave me with? When he said it like that, I was like, damn, yeah, it really is a good point.
Yeah, it's a bit chilling. I'm reminded of, there's a line from a Bare Naked Ladies song called Celebrity that sticks with me with that. And the line goes, I could disappear into the great unknown and it will wear my face as if it were its own. And this idea of like, you don't even have control over your own, the thing that makes you yourself, which is you. Well, enough stuff is out there that we could generate your voice and make it say whatever. And so that becomes a challenging thing too. Like,
Wasn't that also one of the foundational issues of the SAG-AFTRA strike? The most recent one, I know the video game strike is still going on. I don't know much at all about that, but I think they call it like it was basically about AI usage and trying to restrict what could be used. You mentioned deep fakes. There was a fake reality show that was specializing in the use of deep fake technology that was very weird, and it was an example where it was like, see, this is happening and people aren't able to differentiate if this is the real actor or if this is something else. I remember there was oh God, I won't remember it, never mind. But that was one of the things that was finally able to get the strike to resolve. Well, they did not get every AI protection that they wanted. They were able to get a certain degree of protections in place. And like the thing they said, hey, if they're using Brad Pitt's eyes and Jennifer Aniston's smile, then both of those actors need to be able to consent to that. Colton Dunn, who's an actor and a writer who I follow on Instagram, commented on it the day after the strike was resolved about how it's like, I'm paraphrasing what he said. Like, it's basically, this is not everything we wanted and everything isn't great. And I still don't trust these companies necessarily at all, but I have to work.
And I'll put a thing in the description about SAG-AFTRA's deal with AI. But like, yeah, these are kinds of discussions, this question about what agency do figures have over their image, and then balancing that against the ability of, a creator, a film, a novel, a play, a video game to represent figures like that, and where the line is a very complicated question that's still being talked about now. And this again happens at the same time while the courts are going through these questions about like, No Doubt and Manuel Noriega and Ed O'Bannon and Ryan Hart's image rights, is this was coming out at the very same time that video games were finally getting free speech protection under the law in the US. So we have Brown v. EMA in 2011, which establishes the idea that video games are protected speech. As Justice Antonin Scalia wrote in his majority decision, he said, quote, like the protected books, plays, and movies that preceded them, video games communicate ideas and even social messages through many familiar literary devices, such as characters, dialogue, plot, and music, and through features distinctive to the medium, such as the player's interaction with the virtual world. That suffices to confer First Amendment protection, end quote. And as a result, judges in legal cases going forward arguing whether college athletes were entitled to compensation for their names, image, and likenesses had to parse out the new relationship between the rights of athletes to their digital depictions versus this new precedent over video games as protected speech. So it became very fraught to talk about this in terms of where the law stood, because you're developing new precedent at this time. And the question of which right was more important, free speech or publicity, ultimately boiled down to a question of the fundamental nature of video games as a medium. Essentially, are video games forms of creative expression, like film or novels, or are they more like merchandise, like mugs or t-shirts? If they're the former, then their primary goal is to convey messages, like social, political, cultural messages. And thus game makers have a freedom to represent public figures without needing those figures' permission as an extension of free expression. And I can think of some examples of this in like public discourse. For the one that comes to mind off my top of my head are like movies about public figures, like for example, Vice, the movie about Dick Cheney, or like W, the Oliver Stone movie. Would those movies be able to come out? Would they need to get the permission of those figures that they're depicting as like an example of that? And I believe the courts would argue that because they are a form of creative expression, that they are representing an aspect of them that they would not need to. That's my understanding. I'm not a lawyer. But so if video games are like film, then they can have the freedom to represent public figures without necessarily getting their permission. But if they're the latter, if they're more like merchandise, if they're a commodity, then they are first and foremost commercial goods designed to generate profit. And therefore, they would have to gain permission and likely compensation from the real world people whose likenesses they represent. So if they're designed specifically to make money in that regard, they would need to rope in people who they're representing because they're effectively monetizing them. And on top of that, those figures then would be entitled to have a say in how they're presented in those games. And this whole section of this issue, I'm indebted to a July the 11th, 2012 op-ed in Gama Sutra, written by Greg Listoka, who was a Rutgers University law professor who also happened to be a legal expert for EA in the Ryan Hart case. And I'll leave a link in the description because this is really fascinating and really put a wrinkle in how I was thinking about this discussion. And according to Listoka, one of the big challenges for judges in cases like the O'Bannon, Keller, or Hart lawsuits was there was no consistent legal precedent to determine in what instances the claims for right of publicity outweighed the right of free speech and vice versa. And a big part of this is because there were no federal laws establishing consistent guidelines for the right of publicity, leaving up to the states. And state laws can vary wildly in terms of scope and what is or is not considered publicity rights. For example, some states specifically prohibit using a public figure's name and face without their permission, while other states allow celebrities to sue companies for depicting ideas or concepts that may even vaguely refer to their personal brand, and while not naming them specifically, but things that are associated with them. And here are a few examples of how different states can approach the issue from different angles. For example, in 2003, a professional wrestler named Daryl Peterson, who wrestled under the stage name Max Payne, he spelled it with two X's, M-A-X-X, Payne, P-A-Y-N-E, sued Rockstar Games, Take-Two, Remedy, and several other companies for $10 million, arguing they misappropriated his in-the-ring name and identity and damaged his personal brand when they gave their similar but slightly differently spelled name of Max Payne, spelled with only one X, to the protagonist of Remedy's, in my opinion, amazing 2001 neo-noir game of the same name. So they're saying that their Max Payne is infringing on my Max Payne. Payne sued in Utah, and on March the 17th, 2003, U.S. District Court judge dismissed Peterson's case, in part on the grounds that developer Remedy had no prior knowledge of Peterson and his wrestling persona. However, other suits filed on behalf of public figures have been more successful. For example, in 1997, former NHL player and hilariously named person Tony Twist sued comic artist Todd McFarlane, alleging that the equally hilariously named Anthony Tony Twist Twistelli, who is a mob boss character from McFarlane's Spawn series, infringed on his right of publicity and hurt his reputation. And a Missouri jury ruled in the real-life Tony Twist's favor on July the 5th, 2000, awarding him $24.5 million in damages. Now, this legal battle dragged on for years, with the ruling eventually thrown out on appeals, prompting a new trial in 2004, where another jury awarded Twist $15 million, and McFarlane and Twist eventually settled for $5 million. So this long legal battle over, in this case, a name, Tony Twist. Meanwhile, in 2007, billionaire heiress Paris Hilton filed this suit in California against Hallmark, the greeting card company, for printing a greeting card using a photo of her and a riff on her early aughts catchphrase, "That's hot," for which the two parties settled in 2010. And these different rulings in different states, operating with different publicity laws, led Listoka to explain in that July 11th, 2012 op-ed I mentioned a minute ago from Kama Sutra, quote, "So there is no right of publicity, to be precise. Instead, there are 50 different rights of publicity," end quote. And defenders of free speech laws argue that the varying standards would make many game companies who didn't have huge war chests either to pay off celebrities or finance lawyers in the event they get sued, afraid of even making vague references that could be interpreted as connected to a notable figure. For example, as a dramatic example, would a World War II themed title need to get permission for the estate of Adolf Hitler to depict him in a video game?
Yeah, as somebody who is a wannabe creative person, I'm still very torn because on the one hand, sure, you don't want to unnecessarily stifle people's ability to tell the stories that they want to tell. But on the other hand, like there's infinite story possibilities, and if the story you want to tell infringes on somebody else's ability to control their own, name, image, or likeness, come up with another story. Like Call of Duty, for example, like I think one of their things is like, oh, we are trying to be like a, somewhat realistic, historically accurate, maybe like military sim game. So that's why I guess they would say like, we don't have the option to just have, mean, vaguely South American dictator. We have to specifically have Manuel Noriega. But I mean, I don't know, like if I'm playing a video game that's about shooting, just tell me I'm shooting at a mean person. I don't really care who that person's name is.
But the Call of Duty games choose real life settings. Like they could make it a fictional war with fictional characters, but they choose real world settings. And I mean, it would be kind of weird to have a video game about World War II and there's no mention of Hitler.
Yeah, well, in that case, it has to be about fighting Hydra, I guess.
Or in Wolfenstein, giant mecha Hitler. That's different. That's that's a separate
legally distinct. Yeah. So make all the dictators giant mecha versions of themselves in video games moving forward, and we're fine.
Solved. We fixed it.
So one of the things I wanted to come at this from the other angle, Andy, which is like taking issue with defining a commodity. So I see a difference like NBA Live. If you're going to have one cutscene of Michael Jordan hitting the shot over Craig Elo, but he's not in the game and you can't play as him, like then maybe that's permissible because you're just depicting a scene that happened in history, but you don't get to play as Michael Jordan. But what they're saying is that whether Michael Jordan is in that cutscene or whether you can actually play as Michael Jordan are not really materially different because they're both depictions of him in the same commodity. But like, isn't everything a commodity? Like, why disseminate between a video game and a movie? Like, why is a movie art and not a video game?
Well, the courts would argue, and the way they've argued since 2011 is that they are not different in that they are both forms of artistic expression.
Yeah, and I think Michael Jordan, if somebody made a movie wherein they used illegally obtained recorded footage of Michael Jordan and put it in their movie, and Michael Jordan didn't agree to that, I think Michael Jordan would have a case of saying, hey, I did not agree for you to, use me in this. And so same for video game.
You remind me of this is a very 90s deep cut. Has anyone seen the movie Solo? And I don't mean the Han Solo movie, the 90s movie Solo.
No, I've never heard of this. But if it doesn't explain why somebody got their last name, I'm not interested.
I got to bring this up just to make sure I get this right. So Solo was a movie in the 1990s. It was like about a super soldier who they made look vaguely like Michael Jordan. I remember seeing the ads for this where they specifically was like, what should we make our soldier look like? What about like him? And they're showing a picture of Michael Jordan doing a finger roll. I got to see this. Georgia. It's a 1996 movie starring Mario Van Peebles where it's a robotic soldier that was made by the U.S. military and modeled in the likeness of Michael Jordan. And I got to imagine they got Michael Jordan's permission to do this, but it makes me think of that. Like, it's
so if you're going to go to the 90s, I'm going to go back to the 80s and the Weird Al movie UHF, where they show Gandhi 2. Like, so satire is okay, but can you depict somebody satirically in a game and not have to pay name, image, and likeness?
Well, that becomes the other part of this too, is not just the question of like, if we're showing a historical figure, do we need their permission? It's also the question of like, what does it mean if we're trying to parody them or depict them satirically or depict them in a way that they would not entirely approve? You know, that's a good example, the Gandhi 2, where he becomes like an action hero, if I remember right. And so that plays into this too, and what people defending like EA and Activision would argue is like that. It's going to restrict their creative freedom, and basically they can only have a recognizable figure if they either A, have enough money to work with their lawyers to set up a deal where they would have a lot of creative control over that, the likeness people, or B, be prepared to be sued. And there's a legal distinction called a chilling effect, which is basically where a person is afraid to exert their rights, particularly their free speech rights, for fear of reprisal, of lawsuits, of litigation. And that would then make them afraid, and they would not need a law to restrict their free speech. They would restrict it themselves. Is basically what a chilling effect is. As an aside, that's what Jack Thompson endeavored to do to the video game industry. He wanted to make them so afraid of litigation that they would censor themselves. That was Jack Thompson's whole deal. And so going back to Greg Listowka over at Rutgers, he acted as a legal representative and a legal expert in EA's case with Ryan Hart. And he argued in this op-ed that while a ruling in favor of Hart and other athletes like Ed O'Bannon and Sam Keller would be beneficial to college players being taken advantage of by the NCAA, he acknowledges that they're being exploited. He said it would also be devastating for video games as a form of creative expression, writing, quote, "In a world of licensed identities, only those game developers capable of paying licensing fees would be able to make games that refer to actual people of historical interest." That's how he makes the distinction, historical interest. Ironically, even though EA has benefited from its exclusive license to make NCAA football games, a ruling against EA might create further barriers to competition and allow EA and other companies to obtain exclusive rights to even broader swaths of the market for video games. The Hart case is important. If our courts fail to curb the accelerating growth of publicity rights, licensing requirements will threaten creative freedoms. Ryan Hart has a valid reason to complain about his commercial exploitation. If the NCAA can be required to treat its players more fairly, we can solve that problem. But courts should not try to fix the NCAA by endorsing video game censorship, end quote. So that's his thought on it. I don't know if anybody has any thoughts on that.
I don't really see it as censorship to say that you can't use my name, image, or likeness without my permission. I mean, I grant that this is a slippery slope and maybe a straw man argument, but that's like saying, hey, you can't limit my ability to post revenge porn because those were maybe images that you had given to me.
But does this go back to a reasonable expectation of privacy? For instance, an intimate video or photo, well, that would be given in privacy and in confidence and with a reasonable expectation that it's not going to end up on the internet. Whereas I'm thinking, again, if you're a public figure and this is a depiction of you as a public figure, there's less of an expectation of privacy, perhaps. For instance, if I'm walking down the street in Philly and somebody is a street photographer and they take a picture of me, I could tell them, hey, can you delete that? But I don't think that legally I can force them to because I'm walking down the street in Philly. Now, if they kick the bathroom door in at Starbucks and take my picture, I can legally require them to not take my photo because there's a reasonable expectation of privacy there. You see what I'm saying? I think that's where there is some difference. I'm not saying that it's all black and white, but I think that there might be something to say for is it or is it not reasonable given your position as a public figure and as a person who's, you know what I mean? It's like, as a public figure, is it reasonable to say, no, I should have total control over how I am depicted in this game about my life's work? I don't have an answer, but I'm saying like that's kind of where I see a difference between like revenge porn and putting a public figure in a video game in their role as a public figure.
And expanding on that, it seems like a lot of, again, total layperson looking at this, a lot of the debate seems to come to about publicly recognizable figures. And with the idea that a publicly recognizable figure who's in the public forum, who is recognizable for a variety of reasons, an athlete, a movie star, a politician, that there's a certain level that their image is in kind of, for lack of a better term, public domain or public discourse. So like, again, using the example of depictions of presidential candidates, for example, like SNL. They're not going out and getting like Donald Trump or JD Vance or Kamala Harris or Tim Walz's permission to do that. They're just like, they're these publicly recognizable figures that we're putting in silly or satirical situations. Now, of course, there are situations where SNL then has those figures on the show and depicting, sillier things where they negotiate them. Like I remember, was it all the way back in 2008 when John McCain did a joke on SNL where he's doing a telethon to finance his failing campaign. But like, there's a certain question about like who and what is a public figure. And then going back to what we talked about college athletes, is a student athlete a person who is recognizable for playing football? They're on, say, a college football team, or they're on a good college basketball team, or just a college basketball team in general. Does that constitute them being a public figure? And that's really where things get really murky, I think, with this. And again, not a legal expert, but like I think from an outsider's perspective, there's a very big difference between like Manuel Noriega, a person who is a public figure, who is a head of state, versus like, a guy who's a left tackle for like Clemson, who's like the only reason people know who he is because he's the backup left tackle or something, if you're a Clemson fan or whatever.
Yeah, but if your status is predicated on being an amateur, how can you also simultaneously be a public figure?
That's another part of this too.
Oh, damn. I think that is a real crucial piece of the argument. Well,
Yeah,
said,
I think that
Phil.
they kind of want it both ways. Like, no, you're an amateur. That's why we don't have to treat you like a professional. But you're professional enough that people want to buy a video game that you're in.
Yeah, I think you hit it there. I really do think it's a great point.
You know what they say? If you have a paying customer, you have a business. It's like if you have no product and you ask a bunch of people, if I had this, would you buy it? And they go, hell yeah. In fact, here's $20 right now. And like, so if you have a line of 100 people willing to pay $20, and despite the fact you don't have a product yet, you have a business. It's like, oh, well, there's a line of paying customers. I guess I better go create this. So like, if there's a populace of people who is waiting in line to play you in a video game, like, how can you possibly argue that this person is not a public figure? In which case, if you're playing doing what they're doing, they can't possibly be an amateur. That's my opinion.
And going back to what we talked about in our episode when we talked about the student athlete itself, it's like, again, and if I'm recognizable as a public figure, I should be able to, for example, like if I want to make public appearances, if people want to come see me, if people want to pay money for like to buy a jersey or get an autograph from me, then you would think then that gives me the right to do that. But then the NCAA, up until very recently, said that no, you're kind of like our public figure, and like the only people who can monetize, because you're a student, you're doing this to get a very, very good education, and we're the ones effectively monetizing your image. And there is stuff about like how in the NCAA rules for a long time, how you basically relinquished your right to any kind of publicity based on your image. It's a whole weird, murky thing we're not going to get into, but like all this to say, this became a really complicated discussion. And what I think is really interesting about this is Ryan Hart's case in particular is a useful example of how differing judges interpreted the right of publicity for college athletes versus the right of free expression for video game companies. And as I mentioned earlier, Ryan Hart was a former Rutgers quarterback who in 2009 filed a lawsuit in New Jersey against EA for their use of his likeness in several titles in the NCAA football series, including allowing players to use a 6'2", 197-pound senior right-handed quarterback from Florida wearing number 13 if they happen to select Rutgers in NCAA football 2005 or NCAA football 06. And there were also in later installments of the game, you brought up the idea of video footage, Phil. In later versions of NCAA football, you could see footage of Ryan Hart playing, and you could see photographs of him. And in NCAA Football 6, when you boot it up, it'll show clips from older games. And then the question is, are we capitalizing off the likeness of those players too? And so all this plays into it. And on September the 13th, 2011, federal judge Frida Wolfson of the U.S. District Court for the state of New Jersey ruled in favor of Electronic Arts. Wolfson cited Brown v. EMA, which the Supreme Court ruled upon just 3 months before this case, arguing that video games were protected speech and therefore EA's free expression rights outweighed Hart's right of publicity. She also noted that the ability to edit players in the game was enough to consider the likeness of real football players what they call transformative works. And we mentioned this briefly a few minutes ago, but as an aside, transformative work is a concept in fair use law, and fair use basically the ability to use copyright images without getting express permission or compensation under very, very specific circumstances. So fair use is often, for example, in the case of parody, satire, critical analysis, or examples where you don't need to get permission, where you're engaging with the material in such a way. So transformative work is a concept in fair use law that gives the creator an ability to utilize or adapt a copyrighted work, provided that they make sufficient alterations that it can be considered a unique work in itself, while also not acting in direct competition with the work it's transforming. So essentially that it adapts an original copyrighted work in new ways, and it's also not trying to fool people into thinking it's the original work. It's not trying to pass itself off as it. So, for example, parody is generally considered protected under fair use because it's considered transformative. Think about like a Weird Al parody, where he's using a similar sound, a similar music base for it, and similar lyrics, but it's clearly different for comedic effect. And you're not going to confuse Amish Paradise with Gangsta's Paradise unless you're really not paying attention to it.
So, Kevin, I get the point that you're making, but isn't John Dowd competing with Barry Bonds? Like, doesn't John Dowd exist solely to not have to pay Barry Bonds? How is that not competition?
I guess if they were starting to sell John Dowd merchandise and jerseys, that might be.
You're wearing a John Dowd jersey right now.
Now, bearing in mind, this was not authorized by this is a knockoff. So.
Yeah, but people are going to do what you did.
I think you just
do what you did.
I'll send him $5, dear John Dowd. But
like,
yeah,
no,
I don't think that's an invalid opinion to have. I think that's fair observation.
No, it's just hilarious you're wearing a John Dowd jersey right now. That's all.
But yeah, so we've talked about transformative works in the past on the show. Look back to our Pokemon fan game series, and longtime listeners will recall that sometimes when people made a ROM hack or a fan game, people tried to say that it was okay because it was transformative, even though they were basically just trying to make another Pokemon game. And again, look back to our previous series to see how Nintendo handled that and whether or not they agreed it was transformative. They did not. And so, in addition to siding with EA both on protected speech and transformative fair use grounds, in a passage that's downright perplexing to me as someone who knows nothing about the law, and that kind of circles around what we've already been talking about. So, Wolfson argued that EA was not violating Hart's right of publicity either in creating Rutgers quarterback number 13 in NCAA football 2005 or 06, or using an actual photo of Ryan Hart in later titles, such as NCAA Football 10, where he does appear, because they weren't using Hart's likeness to promote the game, and players would only see these digital representations of him after they bought it. So basically arguing just because they're in the game doesn't mean they were for publicity. So obviously, this is like, well, they're not advertising, come play as Ryan Hart in this game, play as quarterback number 13. This is mind-blowing to me. I don't understand this. And on top of that, I will also add that the teaser trailers for NCAA Football 05 and screenshots from the game box do depict digital versions of players. You could argue are being used for promotional purposes. But again, I'm not a lawyer.
Well, I mean, if you listen to enough Supreme Court podcasts, you'll learn it wouldn't be the first time that a judge has made a ruling based on either ignorance of the actual facts or deliberate misconstruing of the actual facts. I mean, the closest thing this kind of reminds me of is, so in DC Comics, they have the character who is popularly known as Shazam, but in universe, he was actually called Captain Marvel. But basically, between the creation of that character and then modern day, Marvel Comics then made their own character called Captain Marvel, and they owned the rights to that name. So in a comic book, you're allowed to have that Shazam character show up being called Captain Marvel. But on the cover, you had to refer to it as Shazam or the power of Shazam. So you know, in an issue of Superman, you know, their Captain Marvel showing up, but it would, on the cover, it would say guest starring the power of Shazam, because they can't advertise the term Captain Marvel. So like that's the closest thing. But again, that's a fictional thing. That's not a real person. Like, hey, I am being told that my main focus is to be a student athlete, and I showed up, you know, to go to class and play football. But meanwhile, here you can like use footage of me to, you know, advertise and make money off of that. Like, to me, that's still a very different thing.
Yeah, it's messy and I'm confused by this and I don't have I can't articulate it other than the way you articulated, Andy, that like it's sometimes interesting to see the limits of the knowledge of judges and the people making decisions that influence our rights. And I could look in the direction of our current Supreme Court, but I'm not gonna talk about that today because it's just gonna make me sad.
Can I make one more point?
Go for it.
I mean, this is a really confusing issue, somewhat in that, like, I think the point you articulated is really valid, Andy. But there are some angles of this. Like, I was like, you're wearing a Dowd jersey right now, but you are effectively wearing it as satire. So does that fall under transformative work, or did you? Oh God, that's so confusing.
Yeah, this is why I'm not a lawyer. And also, I would probably never pass an LSAT.
So if people all just buy the merch ironically, then that doesn't. No, I bought this ironically, I promise.
You have to check a box off when you buy it. Is this ironic? Okay, you're fine.
Dude, are you being sarcastic? I don't even know anymore.
So yeah, this is how when this is initially ruled upon, the courts rule in favor of EA, citing the most recent court case that said video games and protected speech. And so they saw this as falling under that umbrella. And they saw basically this was a transformative work. That basically having this character in the game that also you could alter any way you like with the character editor meant it was effectively a new thing. It wasn't Ryan Hart, it was Rutgers quarterback number 13, who could be coincidentally when you did the name or Ryan Hart, but it could be any name. It could be, it could be Captain Marvel, it could be Billy Batson, it could be John Dowd, it could be anybody. And it seems like that's where they're part of it, is like that because you have the ability to edit them, it makes these characters so malleable as to the point that they're become unrecognizable, even if they were based on a public figure. That seems to be, again, total layperson seems to be part of where they're coming from on this. Now, Hart didn't stick around with this ruling. He filed an appeal. And on May the 21st, 2013, a panel of 3 federal judges in the Third U.S. Circuit Court of Appeals ruled in his favor by a 2-1 vote. According to their ruling, as in the district court, the judges in the appeals court tested whether the use of Hart's image in the NCAA football series was transformative. That is, was Rutgers quarterback number 13 different enough from Hart's real life image that it became an entirely new work owned by EA? But ultimately, they ruled that Rutgers quarterback number 13 was not transformative because it was a representation of Ryan Hart that both fit his physical description and did the exact thing Ryan Hart was publicly known for, that is playing football for Rutgers. According to Judge Joseph Greenaway, who handed down the majority ruling, quote, the digital Ryan Hart does what the actual Ryan Hart did while at Rutgers. He plays college football in digital recreations of college football stadiums, filled with all the trappings of a college football game. This is not transformative. The various digitized sights and sounds in the video game do not alter or transform the appellate's identity in any significant way, end quote. So that basically, this is Ryan Hart depicted in the way that he is known for, that he's specifically a football player. It's depicting him as a football player. Therefore, it is his representation. That it's not transformative, it is him, effectively. That, like in this case, this is a person's right of publicity being violated. They need to be compensated for that. And Hart's ruling helped establish legal precedent in the battle over the NIL rights of student athletes and set the stage for future battles for both Ed O'Bannon and Sam Keller, as well as other current and former athletes looking to get something from a media sports business that generated billions in revenue for the NCAA, their schools, and a host of connected enterprises while leaving nothing for the people competing on the fields and courts. And this victory will help set the stage for future wins that helped create an entirely new college sports landscape, which we will start learning more about next time. And so with that, any thoughts?
I'm just really interested. I'm going to read up more about the SAG-AFTRA strike against video games, like what's going on there, because I feel like that's kind of bundled up in what we're talking about here.
Yeah, this is why I'm an avowed nobody, because I don't want to ever be accused of being a public figure if somebody uses my likeness without my permission.
Well, great. Now I need to stop selling those Andy Hunter t-shirts. Thanks a lot, Andy.
My lawyer, Andy Hunter, will be in touch.
I'll blur out your face on the Instagram.
Like, no joke, I've got merch with Andy and my face on it in my apartment right now that you can buy. It's like, we're not public figures. Oh, Lord, did we try, though? We tried. Well, getting back to the theme of the show, this is one of the most engaging topics I feel like we've covered. There's so many angles, there's so much meat on the bone. I can't wait to hear the next episode.
Yeah, the legal angle alone, just talking about, I'd never really considered going into this topic what the arguments would have been in favor of VA or Activision. And the way I've always seen it, this is, I guess, me in some respects checking my biases on these, is like I always assumed that there was very little legal foundation for, and the argument against it just like it throws such a wrench in my thought process for this. And like I ultimately feel like the way the courts end up ruling, I think that college athletes were being exploited. They had no say or recourse in whether or not they were represented in a game that's designed specifically to sell the product that is them, as opposed to like, a recognizable public figure. If we depict like, the president in a video game, we're not trying to take away any kind of image rights from the president. They're a public figure. One would consider that depicting their images in media is up for grabs. Although it's going to depend. Again, we're recording this before the election is over. That might change depending on who ends up becoming president. And again, given the Supreme Court we've got. But the question of where athletes stood in this, and it seems like in many respects, they got kind of caught in the middle of all of this, where you had like, public figures arguing for their publicity rights. People like No Doubt, and people like Adam Levine, and people like, Courtney Love talking about Kurt Cobain's image. And this is all happening also at the same time that video games now have new constitutionally protected powers that they didn't have either. And the lawsuits, they run in between both of those things happening. And so it's creating this really weird position for games as a kind of topic of legal discussion, that they're sandwiched in this whole question about like, where do rights go, and what is a video game? Is it primarily like a t-shirt, like a mug? There's an article that came out also in defense of games rights in the likeness debate that said video games are not mugs, and trying to argue for the identity of games as a protected form of speech, while also at the same point all of this other stuff about who is represented and how they're represented. And ultimately the question with the college athletes, what kind of agency do they have? And again, ultimately the question, even for people who are defending video games rights in this, is that the athletes don't have any agency. And even with the court cases, like I believe at one point in the Ryan Hart ruling, in the initial ruling, it's like, we empathize with your plight, you're being taken advantage of, but these rights at this point take precedent. Everybody seems to be on their side. It's just a question of where the courts lie on that. And like, it's such a messy topic. And I think that it complicates it so much, but ultimately, as we're going to see, and skipping ahead, the courts eventually start ruling in favor of the athletes. And that sets into motion what led us into the position where, like, I could go to a college football game and have the option to buy a t-shirt with a college football player on it. So that's going to set up where we go in our final month, where we'll bring these threads together. And what we'll talk about in our final month is the other contextual things that were happening in addition to the courts that led to not just the courts, but the court of public opinion tilting against the NCAA, which allowed for a system that we have now where the athletes can have some say and can have some compensation and can have some rights about how what they do on the field is, or on the court, and what level of compensation they can get for that. Things have changed dramatically, and a lot of it was because of video games.
I have one question for you, Kevin. So you bought College Football 25, right?
I did.
If you did not have the ability to create the rosters as they exist today in any meaningful way, like what if it were like, there's a jumble of the same player, there's 53 of the same player, and it would be a Herculean effort for you to go in and like convert them into the rosters that you see today. If it were just a bunch of anonymous people, would you buy the game?
I probably would. My style of play is I like building a dynasty. And often the first thing I do is I go to a low level program that has like no prestige, that has no good players on there. And I systematically rebuild them into a powerhouse, and not often thinking about, this is the first game where I've been able to have a situation where like there are recognizable athletes. That isn't to say I know like anybody who plays, for example, like Kennesaw State or Marshall or San Antonio or any of those schools. In past games, it would have been a number, and the game gave you the option to auto-generate them all names. So I don't have a personal connection to any of those players, so it wouldn't have ultimately, in that respect, probably wouldn't have mattered that much to me. And ultimately, after about 4 seasons, all those players are gone anyway, and you're using auto-generated players anyway. So for my personal playing experience, it didn't factor that big. I mean, I like the idea. I mean, I'm a Rutgers fan. I like the idea that plays Colin Munungai. He's a great running back. Victor Konopka, who's a great in the digital version. He's out for the season in the real game, but there is that appeal. But that all having been said, I'm also glad that they're finally getting something for that. And I actually will say that I started recognizing players in the game in real life. I'll give you one example. Chad Pennington's son. You were Chad Pennington, right?
No. Chad Pennington has a son that's playing football right now.
Yes.
We are not that old.
And
oh my God.
I was doing a dynasty mode, and they have the transfer portal, and players can opt to transfer, and you can try to convince them to come to your team. And Cole Pennington plays for Marshall in real life. And I noticed this name came up when it was in the transfer portal. I was like, oh, Pennington. I remember Chad Pennington. And I didn't think anything of it because I didn't know if it was a generated player or not. And he transferred onto my team. And then I saw like that week or something, or a couple of weeks after that, I think it was on Instagram, they're covering like the children of former NFL players in college football. And one of them was Cole Penny. It's like, holy crap, that guy was a real guy. And so that was an example where I recognized them in the game and then I saw them in real life. And to be honest, like when I played NFL games growing up, the way I got used to recognizing players in real life was through playing Madden. I would have a player I picked up who did really well for me, and that I would see that player in real life, and I was able to connect with like players that way. Like I remember getting Madden 2000, and Doug Peterson was the Eagles quarterback in Madden 2000, for example. So the first I ever heard of Doug Peterson, and then he won a Super Bowl for us years and years later. But anyway, so all that's to say that on the one hand, it isn't a huge selling point for me, the athletes being there. But the other hand, it is kind of neat to see them. I'm glad they're being compensated. And me seeing them in the game is probably going to give me a better incentive to pay attention to them in real life.
So the point I was making, and I'll have to summarize this because we could go on forever. So I think that if you couldn't play as reasonable facsimiles of the current college rosters, nobody would buy College 25. And if that's the case, you have to compensate the players because it's an inextricable part of why it's popular.
I agree. And as a parallel example, there are numerous instances where there has been a pro sports game where they have had the athletes, but not the teams. In fact, the first Madden for the N64, which was just called Madden 64, did not have a deal with the NFL. It did have a deal with the NFLPA. And so you had pro players, but not real teams. And I feel like you could get away with that in a game. For example, using an NFL game, or like earlier games, there was like the MLBPA had a game for Genesis that was called Sports Talk Baseball. It had the players, but it did not have the teams. And I feel like, going on your point, I think you could make a game that sells it on the players, the ability to play as specific notable athletes that aren't necessarily the teams. I don't think you could do the reverse. I don't think you could have like, you know, the Kansas City Chiefs or the Philadelphia Eagles with a bunch of generics. People wouldn't like that. They would want to play as, you know, Jalen Hurts and Patrick Mahomes and all that stuff, you know?
Were you saving that for the next episode?
I was going to bring it up, but I don't mind bringing it up now.
Okay, that's a great point. I'm glad you mentioned it.
All right, I guess we'll wrap up there. And thanks for a great conversation. This was a lot of fun. And that will do it for today's episode of Scandalous Games. If you like what we're doing and want to help the show, subscribe or follow us wherever you get your podcasts and leave us a rating. If you want to learn more, check out our website, scandalousgamespodcast.wordpress.com, where I publish the show notes and the sources for every episode. Our theme music is Occam Seekly by Seek Knowledge via the Free Music Archive, used under a CC BY NCSA 3.0 US license. If you have a question, comment, or idea for a topic for a future episode, email us at scandalousgamespodcast@gmail.com. And until next time, I'm Kevin Impellizeri.
I'm Andy Hunter.
I'm Phil.
I'm Kate.
Thanks for listening. We'll see you next Scandal. Subscribe to Fat Roll Gaming on YouTube and listen to So We Were Talking About B-Scores wherever you get your podcasts.